Hi guys, welcome to my channel once again. Thank you so much for tuning in once again. Today I want to talk about dying declarations. Dying declarations are an exception to the hearsay rule. Maybe some other time I'm going to talk about the hearsay rule and the many exceptions that are under it. Hearsay evidence is not admissible ordinarily in court. It's in layman terms, I would say that hearsay evidence refers to evidence given by third parties, that is by persons other than the witness, the direct witness in a proceeding, third party evidence, where you cannot say that this person actually witnessed what happened in this matter. This person has first-hand knowledge, experience of what they're talking about. For instance, where a deponent has sworn an affidavit and is tendered in evidence before the court, and another party is coming to give evidence regarding that affidavit in court, other than the deponent, that person's evidence will be treated as hearsay evidence. And ordinarily, hearsay evidence is not admissible in court. But one of the many exceptions to hearsay evidence is dying declarations, and that's why I want to talk about it today. Dying declarations are, in simple terms, refer to statements made by someone who is in apprehension of death just before they die. So statements that are made by someone who is in apprehension of fear of dying, and those statements refer to the cause of the person's death or the circumstances involved, which are led to the person's imminent death. For instance, someone has been shot by a known person, and as they are dying, you're trying to rescue them, and they're telling you, oh, Shade shot me, Shade shot me. That's a dying declaration, because they're making a statement regarding the cause of their death and who shot them, whom they saw shoot them just before they fell into the danger of imminent death. Now, that exception is provided for in the Evidence Act in section 40. So I'm going to read it out to you, and then I'll do a little explanation. It's really very simple, and it's one of those exceptions that facilitate justice. Because if someone makes a statement as to the cause of their death, and we come to court and court says that, oh, that statement is not admissible because this person is not here to actually verify or attest to the veracity or authenticity of these statements that you're alluding to them, that it will do a lot of injustice, because the person has already died. A dead man cannot witness to the cause of his or her death. But dying declarations takes away that bottleneck, because it then allows for such statements to be admissible to prove the death of that person. So let me read the Evidence Act to you, section 40, subsections 1 and 2. It says, a statement made by a person as to the cause of his death or as to any of the circumstances of the events which resulted in his death, in cases in which the cause of that person's death comes into question, is admissible, where the person who made it believed himself to be in danger of approaching death, although he may have entertained at the time of making it hopes of recovery. A statement referred to in subsection 1 of this section shall be admissible, whatever may be the nature of the proceeding in which the cause of death comes into question. So that's the provision of law, section 41 and 2 of the Evidence Act. Let me do a little explanation. Now, all evidence before the court must be proved. They must be proved in criminal cases beyond reasonable doubt before the court can act on it. But in a case where someone has died, how does that person come to prove the evidence that they've given before the court? It's impossible, and that's why dying declarations are admissible. A person would be a dying declarant where they have received mortal injury. That's injury that's very fatal, that can cause death, and where they're actually in danger of that death, where they're already expecting to die, even though the law provides that they might have hopes of recovery. But where they are in danger of imminent death, statements that they make regarding what has happened to them, who has caused it, how it happened, the circumstances under which they received the injury, that mortal injury, such statements are called dying declarations, and they are admissible in court in proof of their eventual death. That is, if they eventually die, those statements are admissible to prove their death. There are a plethora of cases, old cases, new cases that are in support of dying declarations. But I'm just going to talk about Akpan and the state. In Akpan and the state, the deceased was beaten by some people and subsequently he died. So he told his neighbor that oh, this set of people, they beat me, they kicked me and all of that, before he eventually died. So in court, that statement was held admissible as to the cause of his death in court. And even though the accused person went on appeal, the court sustained the decision of the trial court and said that, you know, those statements were made in anticipation of death, and they were made regarding the cause of the death and, you know, who did what that caused that injury, that amount of injury that resulted in the deceased person's death. So they were held to be admissible. And now the law is that even if that person had hopes of recovery, it does not matter. So long as they eventually died, those statements they made regarding who did what to them, what caused their death, will be held admissible as dying declarations, just according to section 40, 1 and 2 of the Evidence Act. So there are some conditions, you know, to be met before dying declarations can be admissible. And one is that, you know, those statements must be, they might be verbal, they might be written statements, declarations, but they must be relevant. They must be relevant. That's one. You know that in Nigerian law, in evidence given in court, relevance, admissibility is governed by relevance. So statements are only admissible, evidence is only admissible if it's relevant to the case before the court. So admissibility is governed by relevance, so it covers dying declarations as well. The dying declarations or purported dying declarations must be relevant, whether they are verbal or written. The second thing is that the declarant, that's the person in question, must have died before they become relevant and admissible. The person must have died. So if the person did not eventually die, I mean, there wouldn't even be a murder or manslaughter trial to warrant, you know, giving of a dying declaration as evidence. So the person, the declarant, must have died. The person who said those words before they died, which are regarded as dying declarations, must have actually died. Not just that they were in danger, they must have eventually died before those statements are admissible in court. The third thing is that those statements must be related to the cause of the person's death. It's not just that, oh, an old man is dying now and he's talking about, oh, my child, I forgive you. My wife, I give you my house. My son, I give you my car. No, that's not dying declaration. The statements must, you know, be about the person's death. That is, who caused what, who did what to him, the circumstances surrounding the imminent death. Those statements must be about them. Oh, they were going in the market and somebody shot them. They were sitting around, or they were sitting on their own and a group of touts came and boxed them to stupor. You know, all those statements must be related to the circumstances surrounding that state of imminent death before they become admissible. Then the subject matter of the trial must be the question of the person's death. That is, how did this person die? Who caused the death, or what caused the death of this person? So the question before the court must be the question of the declarant's death, not any other thing. If it's a trial over the person's will, or a trial for adultery now, or a trial for, say, obtaining by false pretense and all those things, then declarations will not even come into play. So it must either be a murder or a manslaughter trial. It must be the question of the person's death before their dying declarations become admissible. And the last thing is that the person must have believed themselves to be in danger of imminent death. I've been saying that since I started this episode. That shows you that it's very important. The person must have been in danger of imminent death. Now, there are cases that differ as to whether they entertain hope of recovery or not. Like in R and John Ogbuewu, it's a very old case anyways. The court held that, the person entertained hopes of recovery, and so their dying declaration was not admissible. But in Akpan and the state that I explained earlier, the court held that even if they entertained hopes of recovery, so long as they were in apprehension of death, the declarations are admissible. And that's the position of the law. That's what the Evidence Act states currently. Even if the person was hoping to recover from the injury, so long as they were in fear that they were going to die and then they eventually died, the dying declarations are admissible. So the person could have said, oh, it was Titi, Bayo, and Shola that stabbed them. That's a dying declaration. Or they could have said that, oh, I saw Mama Ngozi put something in my drink, and after I drank it, this and that happened. That could constitute dying declaration. Statements that are alluding to who did what that caused the person to be in that mortal state, in that state of mortal injury or fatal injury, or in danger or apprehension of imminent death. Those are dying declarations, and they are admissible and relevant, as long as they are relevant to the question of how did this person die, what or who killed this person in court. So that's basically all you need to know about dying declarations. You would understand from explanation so far that dying declarations serve to, promote justice, so that if a person dies and nobody knows or were with them when what caused their death happened, if they are able to testify as to the cause of their death shortly before dying, they can still be helped. Justice can still be served, and criminals and wrongdoers will not go unpunished just because that information is only, in within the knowledge of the deceased. So that's all I have for you on dying declarations. You can read section 41 and 2 of the Evidence Act, for better understanding yourself. And I will always see you in my very next video. Toodles.